Good evening. A very warm welcome to every one of you for joining us for the February 2023 monthly Labourlaw update. In this month, we begin by seeing an amendment that the Karnataka government has brought into the Factories Act, a very interesting amendment, wherein they want to extend, as on date, it's only around an employee at maximum can work only for 10.5 hours. And by the amendment, the government wants to extend it to 12 hours, or of course, subject to a maximum of 48 hours in a week. Similarly, the number of hours an employee can work without a break is sought to be increased to 6 hours, whereas currently it's 5 hours. And it's quite interesting to see the overtime provisions, wherein they've brought in 6-day, 5-day, and 4-day working. So in respect of a 6-day, yes, it's 9 hours. And beyond, if he works, and of course, subject to a ceiling of 48 hours in a week, the employee will be entitled to overtime. But when it's a 5-day working, up to 10 hours, the employee can be asked to work without overtime in a day. And in a 4 days, up to 11.5 hours, basically it goes like 11.5 hours of work, half an hour of break. So up to 12 hours, an employee can be asked to work in a 4-day working week. So it's quite an interesting amendment. And of course, they do say that the overtime workers' consent is required. And women workers can also be employed during night hours. We need to see how this amendment spans out and whether other states are also going to adopt such an amendment. Moving to the circulars, the hot topic that's going on at this point of time is with regard to the Provident Fund Organization higher pension judgment of the Supreme Court, and what the Provident Fund Organization has been doing. Only recently, last week, they have issued a circular to cover employees who are continued to work after 1/9/2014. So they have classified the employees as working before 1/9/14 and after 1/9/14. And a circular has been issued to those who were working on 1/9/2014 and continue to be members or have retired thereafter. In respect of those employees, a joint declaration and what is to be done has been, circular has been issued. It is expected that the Provident Fund Organization would soon be opening an online portal also, this option very soon. And it is understood that yesterday there were also some oral commitments that the timeline, which is currently at 3/3/23, would also be extended further. Of course, as on date, it is 3/3/23, before which employees would need to exercise the option for joint pension. If you require any further information with regard to this, please do email us, and we have FAQs and presentations and short notes, which we would be glad to share with anyone who's in need of what's this judgment and how it operates. Gujarat has brought in an amendment to the rules under the Contract Labour Act, by which it provides that after you apply for registration or license, if the same is not granted within 45 days, or it is not rejected within 45 days, it's a deemed approval, or within 45 days, it's deemed to have been issued. It's a deemed approval that they have brought in. Similarly, under the Interstate Migrant Act as well, they have brought in a deemed approval after 45 days, both to the registering authority under the licensing authority as well. The provisions of the ESA Act have been extended to various districts in Manipur by the ESA department. Specific sections alone have been extended. The state of Himachal Pradesh has given guidelines on how to register employees under the Building and Other Construction Workers Act 1996. It is more for the employees, and they should have worked for 90 days to be eligible for this registration. Moving to the quiz segment for this month, compensation under the employees' compensation should be paid within 3 months, 1 month, 1 year, or there's no time limit for payment by the employer? Is there any time limit within which the employer should pay the compensation under the Employees Compensation Act 1923 is the quiz question for this month. To the next segment of Across the Globe. This is a subject that's been debated even in India at the moment. The Spain is the first state in the European Union to come out with a law that grants leave for women for the menstrual leave, it's called. There are other countries like Japan, Taiwan, China, wherein also it's already been granted. Even UK has provisions for this. Apparently, in India, public interest litigation was moved yesterday before the Supreme Court, saying that the government has failed to form any kind of law in this regard, and therefore the Supreme Court should step in. The Supreme Court of India has rejected the public interest litigation and has held that the petitioner can approach the Women and Development Ministry for redressal of the grievance, and said it's a policy matter and that therefore they will not be able to interfere with it. An interesting case of a hairdresser in United Kingdom. They do come, but despite that, she takes off, and the employer is under the impression that it is on purpose, that the employee is doing the same, and he fires her from employment, and then she raises a dispute wherein she says she was suffering from a medical condition, and ultimately the employer is made to pay a fine of around £3,400 as compensation. In our knowledge corner, we look at commencement and conclusion of conciliation proceedings under the Industrial Disputes Act. Why is this relevant? Section 33 of the ID Act requires employers to ensure there's no change in conditions of service, there is no dismissal or termination during a conciliation is pending. So the question comes as to when is a conciliation pending, and that if employer violates Section 33, the employee can file a complaint against the employer under Section 33A. And therefore, it becomes relevant to see when is a conciliation proceedings pending, or when a dispute is pending per se as well. Section 20 is a specific provision which provides as to when a conciliation proceeding is pending. And it says that a conciliation shall be deemed to have commenced once a strike or lockout notice is issued under Section 22, and it is received by the conciliation officer. Similarly, a conciliation is deemed to have been concluded when a settlement has been arrived at, or when no settlement arrived at, once the conciliation officer sends the report to the appropriate government and the appropriate government has received it. And also when a reference is made to the court during the pendency of conciliation proceedings. Similarly, it also when during proceedings before an arbitrator shall be deemed to have commenced on the date of which the reference is made. So the dispute may not even come to a labor court, but once the government makes a reference, from the date the dispute is deemed to be pending. Many employers fail to note that if there is a 2K dispute that has been raised and proceedings are pending, they cannot change the conditions of service, nor can they terminate or dismiss an employee either without seeking approval or permission if the employee is connected to the dispute. Therefore, it is extremely relevant to understand when a conciliation or a dispute is pending, because any dispute, dismissal or termination without following Section 33 is held to be void by the Supreme Court. Therefore, it is extremely essential to understand when is a dispute said to be pending. So this is how the specifically Section 20 deals with it. And that's how the clause provides for it. In the Did You Know segment, the NEEM scheme was scrapped by the Ministry of Education in December 22. But the question is whether it is prospective or the existing NEEM trainees are to be affected. The Delhi High Court already had granted a stay, and now the Madras High Court have also said that the NEEM trainees were already enrolled cannot be disturbed until the disposal of the writ petition, and has granted an interim stay. In the case law corner, we move to see two judgments. The first one is where is a judgment of the Supreme Court arising from the state of Maharashtra. State Financial Corporation extended the benefits of a pay commission only to employees who are on rolls as on 29/3/2010, and those who had retired or died or were left under VRS or resigned between 1/1/2006 and 29/3/2010 were not given the benefits, challenging which they had come up, and the court held that people who had worked between this period, that is January 2006 and March 2010, would be entitled to the benefits of the pay revision given by the pay commission. But the exception that was drawn out was voluntarily retired employees. The court observed that those who had voluntarily left the services, availing a VRS and collecting an ex gratia, they cannot have any claim against the employer in terms of the pay commission. This is a case under the Gratuity Act. Madras High Court and the Kerala High Court have taken a view that an employee has worked for 4 years and 240 days would be entitled to gratuity. In this case, it was a case of 4 years and 10 months and 15 days. The applications were allowed by the original authority as well as the appellate authority, but the High Court, a single judge of the Karnataka High Court, has held no, the understanding of law by the Madras High Court is incorrect. Section 4 specifically mandates continuous service of not less than 5 years, and therefore, unless a person completes 5 calendar years, he will not, 60 calendar months or 5 calendar years, the employee will not be entitled to gratuity. And Section 2 capital A will not come to the aid to say that 4 years and 240 days would also entitle an employee for gratuity. So it's an interesting development, this judgment. It's slightly few months old, but we thought this judgment is something different from what Madras High Court and Kerala High Court has held. So we need to see the development of law in this aspect. In our Lex Posh segment, we get to see a judgment wherein the High Court went on to grant a compensation. The employee concerned had made a complaint against the managing director, against the director, and which was placed before the managing director, which in turn was placed before the IC. The IC found the employee to be guilty and directed him to tender a written apology. The management was also given liberty by the IC to take any other measures in terms of their service rules and policies. The respondent filed an appeal which came to the board of directors. The board of directors found that there was some kind of a lacuna in the constitution of the IC and it was not compliant with the requirements of the law. And therefore, they remanded the case back to the IC to relook on the issue. The High Court held that such kind of procedural irregularities cannot be a ground to send it back. They found that it would be an embarrassment both to the complainant as well as the respondent, because they have to undergo the inquiry once again. And after observing the same, the High Court granted a compensation of 1 lakh to the complainant, and with that it dropped the proceedings. Our last segment before we go to that, the answer for the quiz question is that 1 month from the date of accident, the compensation amount should be paid. The last segment for today, the complaints calendar for March 2023. We would be sharing the PowerPoint to those who have logged in, and you could have a look at what are the different complaints that it needs to be done in March 2023. Please do join us on 25th March at 4 p.m. for the March updates on labor laws. Thank you.